All right, this is the November 15th, 2024, 9 a.m. Noticed public meeting of the Child Support Guidelines Committee under the Department of Health and Human Services. I'm the chair, Kim Surratt, and we are going to start with taking a roll call and determining whether we have a quorum. Kathleen Baker. Present. Ellen Crecilius. Here. Kirsten Gallagher. Assemblyman Gray. I believe he's here. He's on the screen. You're shaking your head. Yes, I've got you.
There we go. I could turn it off. Thank you.
Perfect. April Green. Judge Hoskin.
I'm here.
Adam Hughes.
Present.
Justice Lee. Judge Robb. I do know we are attempting to get Judge Robb. She's trying to get into a link, so we'll hold her kind of in abeyance right now. Judge Shirley. And myself. So that puts us at 6. We do need Judge Robb pretty desperate at this point.
Cool. And Jeff, is mine working? Yep. Jeff Weed from the Churchill County District Attorney's Office.
Oh, you aren't on the list, are you? Yep, I've missed you. You're my 7th. Jeff, you are here. Perfect. We do have a quorum. But we do want to try to get Judge Robb while we're working on that. All right, perfect. All right, my friends, thank you. We have a quorum. We will move on to the second item on our agenda, which is general public comments. We do not take any action during the public comments. Anybody that is present is welcome to speak. I will limit your time. We have a casual agenda today, so I will allow it to 3 minutes. We will start with Las Vegas. Is anybody present in Las Vegas that would like to give public comment? Seeing
There's no one present.
All right, thank you. And there's no one present in the Carson City room right now. Is there anybody on the phone that would like to give public comment?
Thank you, Chair. To provide public comment, please press *9 now to take your place in the queue. Caller, please proceed. You are unmuted.
Madam Chair, this is Bridget. Rob, I am at least listening to the hearing and will try and provide anything in any way I can do so technically until I get a link to be able to participate. And I am very sorry. I thought I saw a Zoom link on the agenda. I was mistaken, and I apologize for not being there in person.
You're welcome. Thank you. I appreciate it. For those listening, if you are part of the public, there is a link that is provided for the public, but it is for public comment, what we're doing right now. So do we have anybody else that is available or would like to speak during public comment on the phone?
Chair, the public line is open and working. There are no additional callers at this time.
Okay, thank you. I appreciate it. We will move on to agenda item number 3, which is discussion and possible approval of the meeting minutes from August 16th, 2024. Do we have a motion? Anybody
Judge
read
Hoskin
them?
for the record.
Yes. Did you motion, Judge?
I did. Maybe you were talking over me.
I talked over you. I love you. Okay, we have a motion from Judge Hoskin. Do we have a second?
Kathleen Baker, second.
All right. Do we have any discussion? I have one comment to make. When we do the meeting agenda minutes, we need to be very cognizant of titles. And that would include not just our legislative members, but our judges and our justices. We need to make sure we reference them as by their formal titles, if we could, please. Do we have additional comments?
I had a question.
Yes.
Comment. April Green.
I
had thought about attending by Zoom. I didn't see a link. I recall from the last meeting that I think we said either way, come in person or video. So is it me or was there not an option?
If any of the committee members want to attend by Zoom, you must reach out to Joy when she gives notice, and they have to obtain a specific Zoom link for you so you can participate as a committee member versus just the public. So it will never be on the agenda that way because it changes the dynamic of how you participate.
Got it. Thank you.
You're welcome. But yes, during the last meeting, the conversation was that we would allow participants by Zoom or in person, either one. Okay. We have a motion and a second. Any further discussion? Hearing none, all in favor, state aye.
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 Anyone opposed?
Aye.
Anyone abstain? Okay, motion passes. Thank you. We will move on to agenda item number 4, which is to elect a co-chair pursuant to NRS 425.610 subsection 3, which states at the first regular meeting every 4 years, the members of the committee shall elect a chair by majority vote who shall serve until the next chair is elected. Now, that statute does not specifically state a co-chair, but we have historically had a co-chair, and the goal is when the family law section finally finds a replacement for me, I want to move our co-chair into the chair position. This will allow for some training, obviously. And to be blunt, and unless he withdraws his willingness, Judge Hoskin has stated that he would be willing to serve as the co-chair and then subsequently as the chair. Are you still willing, sir? I'm nervous about asking.
No, we did have that conversation and reluctantly willing, yes.
I have to say how much I appreciate it. After the last meeting, no one else has expressed a desire. If anybody else has a desire, please state so, because obviously you heard Judge Hoskin say reluctantly, but I think the institutional knowledge is important. If anybody else is interested, please let us know right now. Okay. Do we have a motion for Judge Hoskin to serve as co-chair at this time?
I move for Judge Hoskin to serve as co-chair of this committee.
Thank you. And a second?
Kathleen Baker, I second.
I started seeing.
And Kathleen Baker was a second. I'm not positive your mic worked. Did it? Maybe. All right. We have a motion and a second. Any further discussion? All in favor, state aye.
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 I mean, I thought that yesterday.
Anyone
How do we even
opposed?
Switch over.
And anyone abstaining? Okay, thank you. I think we keep losing Assemblyman Gray. We now see broadcast on the screen, just as a warning, Joy. We keep getting weird feedback on it.
I don't know if you can hear me. I've got a very unstable signal and I don't know why. I keep losing video and then I'll lose audio, so I apologize.
Okay, well, we can hear you, so that's a good sign. So we'll go with hearing you and not stress about seeing you. All right, thank you,
All
sir.
righty.
All right.
All right, thanks.
Okay, we will move on to congratulations, Judge Hoskin, to finalize that agenda item. Agenda item number 5, discussion of concern voiced by Nevada's low-income legal services provider regarding the court's obligation to consider the reasonable cost of childcare paid by either or both parties and make an equitable division thereof pursuant to NAC 425.130. And do we still have an empty room down in Vegas?
We do.
Okay. I reached out to legal services again and let them know we tabled this from last time and was very hopeful they would send somebody today to talk about their concerns on this item. And it looks like we will be tabling this item yet again.
Madam Chair, it's
Yes.
April Green.
Yes.
I happen to work at the Legal Aid Center and I have been briefed on their concern. I don't know if it's appropriate or not to
Perfect.
share.
Absolutely. Please fill in. I just knew it was somebody else that voiced the concern, but if you are prepped for it, you are on the stage, my friend.
All right, thank you. So I don't have much to say, but the idea is that there was an expectation of proposed findings that would need to be made in order for the court to make a determination regarding child care obligations. And the concern here in the South is that the judges are already inundated with making findings, and their decisions are often challenged because they and reversed. Decisions are reversed for lack of proper findings in custody and support orders, and that adding even more findings won't help. So that we are opposed, basically, Legal Aid Center is opposed to the proposed language for those reasons. They are hoping that we can come up with a more simple formula, because at the Self-Help Center in Clark County, people are struggling hard enough, the pro se's, to handle court orders and do these things adequately. And this is going to make it even harder for them and harder for the judges. So they're looking for a more simplistic way or formula to deal with child care contributions. Thank you.
Okay, do we have any comment from the committee?
Judge Hoskin, for the record, is the request that we eliminate this requirement or clarify the requirement?
I believe clarify and modify.
So that childcare is considered and divided, or that it's not considered and divided?
I'm just going to speak for myself, considered and divided, but on a better, an easier way to come to numbers.
Okay, and has legal aid proposed any language for us to consider?
No, but if you could table that part of it until the next meeting, I'm sure that they will.
I think, from my understanding, from when this was brought to me, the issue is just about the articulation of the findings of fact, especially when there's requests for a proposed order to be provided to the court, and the ability for pro pers to articulate well enough the findings of fact in writing. And I don't believe, my understanding is, I don't believe the idea was to get rid of any of the calculations on childcare or the division or how we divided it. For further clarification, that this issue of this language should technically, it should be going from the department to Ledge Commission, and I have no idea if it's on the agenda for Ledge Commission today. And Ellen's not technically, Kirsten's not here today, so we don't have somebody with the division that can tell us exactly where it is in the process. But so it's basically being introduced at the current level for the last set of amendments that we just did. So if we change that, it's not a problem. It's just a matter of, it's going to have to go in our next set of proposed amendments to the amendments we just made, I just said the word amendment 5 times, I think. So, technically, just to show the committee what we need to do with that, that's how we'd have to move forward. In terms of timing, we are butting up against the next session, and so there is going to be difficulty in scheduling this committee. I am going to be having a very strong conversation with the division about hopefully Zoom meetings for this committee when session's in play here in this building and we can't get into the buildings. So, but other than just telling judges not to articulate the findings of fact, I guess we're looking for a creative solution to that. Hello, Judge Rob. Did we lose our Assemblyman Gray? It looks like it on the screen.
I've got him on my screen.
Oh, do you? Okay, good. So we have your picture and his voice maybe. So perfect. Judge Rob, did you hear what we're on agenda item number 5 right now? I don't know how much of this you heard.
I have been listening to the entire meeting.
Okay. Do we have other committee comments on this agenda item? I guess we don't have an understanding. Is there a concern for this in the north also? Do we know, Ms. Baker?
Kathleen Baker for the record. And I have not heard anybody express any concerns to our office at this time. Of course, the amendment that said that the findings have to be made hasn't been put into play yet. So we may start hearing something after that occurs.
Okay. Any further committee comments?
So Judge Hoskin for the record, so are we tabling this to see where the language ends up and see if we need to continue to, how are we going to?
Yeah, I think the proposal may be to for sure table this. Number 2, hopefully, Ms. Green, if legal services could work on what their proposal is on amending it. I think we're all ears. There's not like some extreme feeling about one way or another about it. It's just not knowing what direction to go to fix the problem. Because we still want the court to put some brain power behind childcare, which was the goal with the new set of statutes, and not just a one-size-fits-all for all families when it comes to childcare. And actually think through all of the facts, right? Whether they actually make it into the order versus just on the record, that's a completely different issue in my opinion.
Okay, thank you.
Thank you, we appreciate it. All right, so I'm going to table agenda item number 5. Agenda item number 6 is discussion of public concern expressed to the chair regarding the need for the committee to consider the use of income tax deductions and income distribution among the parties in child support matters. That is a very generic description of what the concern was that was expressed to me. And I am going to actually read the email that was sent to me. This is from a citizen here in Nevada. And for the public, we really appreciate receiving input from the public. I need to set some comments out there for the public in doing so. We are not an enforcement body. We have no control within this committee over any of the statutory mechanisms over enforcement or modifications. We are about setting child support. So parts of the email that were sent to me were concerns regarding the modification, the rate of speed of modification, and issues regarding enforcement on that. The part that is in this email that is relevant for this committee, I do share. When I receive public comment, the comments go to this committee, and I make sure that the committee considers it, because I want the public to know just how important it is that you come to us and that we do hear from you. And even if they are issues that we have already resolved, I want us to hear your concern and then express whether we've resolved it or not, or whether we need to continue to address the issue. The issue expressed in this email is one that I have very passionately pushed for on this committee, and due to the division's unilateral decisions regarding our proposed amendments last time, they completely ignored the efforts to balance joint physical custody child support. And the comment made from the division on the record and to me both was that they cannot pass anything or support anything that puts somebody in financial dire straits or causes them to need welfare. The example proposed in this email is exactly where I think you are wrong in that statement, that often the joint custody child support calculations do exactly that to the payor. you are only looking through one lens at the payee, and you are not looking at the payors and what it does to them financially. But here's the email, and I apologize for it being a little bit long, and keep in mind, I do know there's parts that are irrelevant to our committee on enforcement, but I want you to hear the story. And I want the division to hear it, even though they're not here today. So hopefully through the meeting minutes, some kind of influence can be had. I applied with the district attorney's office to have my child support modified. It takes 6 months for them to modify it. I am currently working, so the request is denied. I owe money and back child support. I have rent that is $1,500, car insurance $300, as well as various other bills. I received $292 a week in unemployment after child support was taken out. I was in the negative for 6 months and forced to sell my personal belongings to survive. There needs to be a more efficient system to modify child support and when someone loses employment. The current state laws caused me severe financial hardship. Also, my daughter suffers if I become homeless and without a car. I've stated that I have joint custody. I am now receiving threats from the district attorney's office for my driving privileges to be revoked because I owe back child support. I live in Las Vegas. I am working at State Line. My commute is 50 miles each way, so 100 miles a day. If I lose my license, I lose my job, and I will not be able to pay my rent, provide insurance for my daughter. So my daughter will suffer because of the inefficient laws in the state of Nevada. Something needs to change in the laws. I'm punished because my daughter has a deadbeat mother that refuses to work. I would gladly take full custody of my daughter, by the way, but as you know, Nevada normally rules for joint custody. If you can explain to me why I'm punished and my daughter is punished by laws that are supposed to have the best interests of the child at heart. If there is joint custody, there should be no child support. You are punishing a parent that is responsible and rewarding a parent that is irresponsible. The law is broken. It has caused me severe financial and emotional stress. I work construction. We finish projects. Last year, Fontainebleau, the Sphere, Durango Station, and 2 other large solar projects ended. I am a member of IBEW 357. It took me 6 months to return to work. There is no system currently in place to safeguard people who become unemployed from getting behind on child support. It builds up and becomes overwhelming, making an honest person a criminal because they literally don't have the money to pay it. The comments on the record were the payee is the one that ends up on welfare. The payee is punished. And in this scenario, you've got a hardworking parent with their child in their home 50% of the time, and nearly all of their unemployment money while they were on hardship, because this happens a lot to these construction workers in the state, especially these union workers. These projects come and go. They come on and off of unemployment. Now, I get the modification is not in front of this committee. I understand that the issues regarding the speed at which perhaps the district attorney's office is not working at in order to create modification is a problem. But I think part of the problem, and what you have to really look at in this case, is the fact that you've got a parent who has the child in their home 50% of the time, who's trying to work, who can't make ends meet, and is suffering under unemployment conditions while the other parent is not working and just receives the difference in the child support. We were talking about balancing it. Even our balancing that we tried to propose and didn't get passed last time wouldn't fix this problem. But I think it deserves respect of this committee to take a look at what happens in joint physical custody with a parent completely unemployed and one employed, and whether that calculation makes sense. The division did not accept the fact that we just wanted to balance the two. So when I say balance, what was recommended on the last reiteration and was denied unilaterally by the division, even though the committee passed it, was that you take the difference between the two and you owe half of it so that you have a balanced child support obligation. Each party receives a balance. The testimony that just really, really bothers me, again, is that we are taking from that poor recipient parent, but we're putting zero consideration into the payor and whether they can make ends meet, yet they have their child in their home 50% of the time. I understand this is a little bit of a soapbox, but I also want the public to know when you send any email like this in, I am going to bring it to the committee, and it may not be as passionate as this because this is an issue I have a concern with, but it will come in front of the committee every time. Now with my long spiel, does anybody on the committee have any comments?
Judge Hoskin, for the record, just a procedural question. Perhaps we addressed this at our last meeting and I just don't recall. Is our change to that regulation still pending? Do we have to redo that in this iteration of the committee and resubmit it again, or is it just not going forward?
It is. It did not go forward last time. We could continue to make the recommendation or variations on that recommendation, new versions of a recommendation to the division, and perhaps at some point have enough evidence to explain what the issue is and what the need is. But the last one did not move forward. They never submitted it to their public hearing, so it can't go to Legislative Commission. Is there further committee
I have
comment?
a comment.
Yes, ma'am.
Yes. April Green. I just wanted to say that that letter, to me, the essence of it was really the failure to be able to timely modify someone's child support obligation due to unemployment. And the person made a good point about all those projects ending and how that happens to people often here. So I think we should, maybe we could create some kind of proposal that would force them to be able to address emergency modifications.
Judge Robb, I know you have your hand up. The only concern, we as a committee do not have jurisdiction over modification. We only have jurisdiction over calculation of child support under the original statutes that created this committee. So to the extent we can assist, it's about what happens with a joint physical custody scenario because when the other parent is unemployed. Because that's the other half of the essence of this is that when he is employed, the other side is not employed, and he has a very high child support value owed. Judge Robb, you're next, and then Ms. Baker, you're after that.
Thank you, Chair. Going back to exactly that issue and my distress with the just kind of disposal of work of the committee, Judge Hoskin and I both, when we make decisions, we have to have evidence to support that decision. And one of the things that dismayed me the most with the determination by the department to summarily just not go forward with this portion of our recommendation is that it appeared to me to be based on perhaps anecdotal understanding or maybe just a feeling, but I didn't see that it was based on any kind of evidence whatsoever. And I think disposing of the work, again, of subject matter experts who are in the field doing this in court on a daily basis, dealing with the constituents, that was really troubling to me. And so to the extent we can bring this back and perhaps as part of new business, ask that there be a study to see if the understanding of the department is actually accurate and it would cause people on one side of the equation to, or more people, to be placed on public assistance, I'd be interested in knowing that. Because right now that decision was made without any underpinnings, and it troubles me, and I agree wholeheartedly with you, Chair. It places the obligation unfairly on the payor to support children when the policy of the state of Nevada is both parents support their children.
Ms. Baker?
Kathleen Baker. I just want to speak to the issue of the burden being on both parents to support, responsibility being on both parents. I can't speak for other enforcement programs, but I can state that with the Washington County District Attorney Office Child Support Enforcement Program, that when we have joint physical custody, we put emphasis on both parents for the responsibility of supporting the children. With somebody who's in a seasonal job, that is challenging regardless of whether they have joint physical custody or primary physical custody. In seasonal jobs, we really try to do an average income per month and use that. However, I think that part of the dilemma is not being able to get in for modification hearing. We're setting out about 10 weeks right now, which to me is too far. I would like to get a setting earlier, but we have some limitations. That said, we get somebody in and they are unemployed, we will look at either their ability to pay for that period of time. And we frequently will zero out the obligor's obligation until such time as they are able to pay. We also hold the obligee, or in a joint physical custody situation, they are also considered obligors pursuant to the guidelines. We hold them also responsible for getting employment or being able to support their children. So I think there are issues that need to be addressed, but I do want to say that at least with respect to the Family Support Division, that we are cognizant of those, that we do our best to address them to make certain that we do not have a payor who is out on the streets, because that doesn't do anybody any good.
Additional committee comments? Yes.
Madam Chair, Adam Hughes.
Oh, hi, Adam. Thank you.
Thank you. I'd also like to echo what Ms. Baker said. Speaking on behalf of Clark County, the DA's Family Support Division, where this customer that wrote the letter had an interaction, I'd like to first thank the customer for their, or the citizen for their letter for the committee's consideration. I'd also like to express my sympathies to the citizen for not only what they're going through, but for their experience with my office. I'd like to explain the 6-month child support timeline that the citizen provided in the letter. So that timeline comes from the federal regulations. They require us to process modifications within 180 days. So that is the timeline that we provide to our customers, but we often complete the modifications well before that timeline. So when our office receives a modification, we first try to stipulate with the parties, and if that can be done, modifications are typically done within 30 days or less. If they have to go to court, our time to get into court right now is the 35 days pursuant to the EDCRs. So we're not out past that. So it's we're in court timely. I'd also echo what Ms. Baker said about union workers or individuals with sporadic employment. We do average their income for setting child support orders, so that the order considers times when they're making great money. It might be a little bit less than what would be ordered. When they're making less money, it might be a little bit more than what they're receiving. But again, these are all good considerations for our community to hear and to think about why we're reviewing these rules. Thank you.
Thank you. Any additional comments from the committee? All right. I think a couple of things came out of this, that when we discuss future agenda items on towards the end of the meeting, we'll discuss adding those to the agenda so that we don't, this isn't a done issue. I want us to continue to discuss it. And one of the items that Judge Rob, you brought up, I'll make sure I'll bring up when we talk about future agenda items. All right, thank you. All right. Agenda item number 7, discussion of whether the Nevada Supreme Court's holding in the case of I hate saying this name, McClellan v. Davis, whatever it might be, allows courts to exceed.
McCulloch.
Is that what it is? McCulloch?
McCulloch.
Versus Davis. How about 516 P 3rd 667? Allows courts to exceed the authority to adjust an obligor's base child support obligation under Factor F of NAC 425.150, subsection 1. And at this time, I will check once again with the phones if we can, because this person who submitted this for an agenda item, it was tabled from last time. They were invited to come again this time, and we have no one physically in the building, so is it possible to check the phones to see if we have anybody present?
Thank you, Chair. To provide public comment, please press *9 to take your place in the queue. for agenda item number 7. Chair, we have one caller in the queue, but there is no response.
Okay, thank you. All right. If there's no response, then I'm going to remove this agenda item and not table it this time. If this concern came from a private family law attorney in Las Vegas, if it is an ongoing concern, you've got to show up and you've got to give your information. This committee, while we can guess what the issues are and concerns were regarding this issue, I did not receive additional information. So we need you to attend these meetings. So in addition to the citizens of Nevada that are payors or payees of child support, the attorneys and other professionals within our industry who have experience in these cases, we need you. We need you in front of this committee. We hear lots of complaints out in the world about child support, and then we hear crickets when we come to these meetings, and we don't receive the input that we need. So I will remove this from the agenda now and
Madam
not
Chair.
table it. Yes.
I also raised a concern with regard to this when the case first came out, because of the finding by the Supreme Court that there is a cap, and the cap is created by 1F in that regulation. And my recollection of when we put this together was we were very clear there would not be a cap. So certainly if this committee decides that having a cap and the cap being the obligation of the other party, then we can move forward. I just wanted to make sure we were all on the same page with regard to the finding by the Supreme Court. There is a cap in the regulation, as opposed to the determination this committee made from the last go through that there are no caps. So I do think this needs to be addressed and resolved by the committee, notwithstanding the individual who raised it, because I think I raised it in the last iteration concern when this case came down.
Okay.
So I don't know, table it without at least a discussion to make sure that we're on the same page with regard to that issue.
No, let's not table it then. Let's have the discussion. I will, just as a little bit of institutional knowledge, because we do have members here that were not here during our first horrid, long, extreme number of meetings that we had to go through the child support calculations. The intent, the overall intent of the committee was that there are no caps, that we were getting away from caps. However, under that specific issue within the regs, we did feel that at some point it hit a point of being punitive versus, and I guess that's my interpretation on it, is that it's not that it's a cap, it's that it was to avoid a punitive modification of the child support. I don't know if that makes any sense. Is there anyone else on the committee that wants to comment or recollections of our communications on that?
And I agree exactly with the way that you framed, Judge Hoskin. Exactly the way that you framed it was the way that I had an understanding. The problem that we have at this point is now it is interpreted as a cap. So we can leave it at that if everybody's okay with that is the cap in there, or we can make some clarification in the language, adjustment factor or discretionary factor for the court as opposed to a cap. That my only concern is the language that the Supreme Court has put in place with the regulations that there is, and cap is referenced throughout that decision.
This is Jeff Weed. I was not here for all these previous conversations and what the intent was. Was the intent that it would be on the initial calculation there would be no cap, or did that also include these adjustments? Because obviously there's an initial calculation, there's no cap associated there, but then we have these adjustments that sounds like are not punitive, or those kind of things. Was the intent different for those two?
Yeah, I think my interpretation would be that it's on the adjustment that we didn't want it to turn into being punitive, that you adjusted so far that it became punitive. But that on the initial calculation, I mean, that was the one thing with the high income families that we definitely were getting away from the brackets. Obviously, we don't have our brackets anymore. And those brackets were very definitive caps on child support, and that there were many families where that top number didn't make sense within the context of that family and the numbers and the math and the needs and the lifestyles of those families. I know there was initial immediate reaction by some of the private attorneys that there were some very outrageously numbered child support calculations. This committee left that to the discretion of the judges to decide at what point does that stop, you know, without being a cap from us saying, because we were getting away from trying to know what all those family circumstances were, or those special needs of certain children were, you know, in trying to encapsulate all of them in the statutes and know we covered all of them, right? Without leaving it to the discretion of the court. It's just that when you start adjusting based on our other factors, it was like at some point we were feeling like it was punitive. I can tell you, we did struggle on that language, on that section. We really struggled with word choice. And maybe the issue is we need to go back and really look at our word choice on it. Because I don't know how other than this testimony and the meeting minutes from this committee, and actually I don't remember in that case, did they go to our meeting minutes at all? The Supreme Court in usage of any of us?
It's not indicated in the language.
As
the language
legislative
itself
intent?
indicates that it's clear.
So I don't know that us sitting here and
language is-
talking is enough, right? Without making a change.
Correct.
But I don't know that we can go into a statute and say, "Dear Supreme Court, there's no cap." So what word change fixes that issue, right? Within the statute. Is there do you have a suggestion on how to fix that?
What I'm looking for is clarification, because you and I and several others of us, after we did this the first time, did CLEs 20 different places and told them there are no caps. And now this says clearly there is a cap. So if we are okay, and I don't know if I have a feeling one way or the other, because I like the way the language is written, I like the way that we did it the first time, I don't think it's a cap. And if we're okay with the Supreme Court defining it as a cap, then we can move on. But I think that there is a cap, then we probably need to re-clarify something down the road, because you and I both, when we're explaining this, explained very clearly there are no more caps. So that is my only concern. I don't know that I have a fix for subsection, because I think that it's correct and in line with what we decided previously. And maybe we leave it at, we have the minutes from this meeting indicating that we didn't think it was a cap, but it was more of an adjustment to make sure that everything is right-sized. And we move on from there. And I don't want to beat a dead horse if we're not willing to do it. I just want to make sure we're rest.
Any additional committee comments?
I thought Judge Robb had her hand up, but maybe not.
Well, I can see it on her face. It looks like her hand's up in her face. She's thinking. You're
You know
muted.
me too well, Madam Chair. The only thing that I would say is, yes, I have come across using this particular statute, and it is used very infrequently. And there are times when using it in the way that the Supreme Court has decided can work a hardship. I have one parent who is independently wealthy with another parent who is working 2 jobs to try and support the children. And would it be appropriate in that circumstance, especially when the wealthy parent is using that wealth to berate the working parent, because that working parent is unable to provide some of the additional supports for their child that the wealthy parent is able to? That circumstance is a problem, but it's only a circumstance I've seen once. And I don't want to get into the weeds with what we're doing and try and fix every single problem if it's only going to be a one-off problem rather than something that we see all the time.
Any additional committee comment? All right. Judge Hoskin, do you think if right now we just kind of resolve ourselves that we're saying it's not a cap and we have our information out there as our committee intent on it for now, and we wait and see if it comes up and it does become a greater issue with our judges or anybody that's practicing, please bring it back to us and let's see if we get more case law from the Supreme Court that's obviously misinterpreting it, then perhaps we need to figure out a different solution on the language.
No, I wanted to make sure that we had the conversation and the committee was all on the same page. It sounds like we are. I agree with Judge Rob. I've never applied this section of the regulations in any case that I've had since it's been in place. So it is a minor issue. I do think we are tasked with fixing all of the problems. Perhaps this is not a problem that needs to be fixed. So I'm okay with taking it off the agenda based upon the conversations we've had.
Okay, thank you. All right. All right. Agenda item number 8, discussion and possible approval of ideas for future agenda items and the next meeting date and time. So there's kind of a threefold issue going on. One would be we need to ask the division to come forth with what they are doing for the new audit. They are, we pushed the statutes a little bit with interpretation because they are to do an audit every 4 years, and we are well beyond 4 years. But the new statutory authority went into effect in February of 2020, so there was a little bit of an analysis of we didn't have 4 years of the new statutes under our belt for a auditor to even look at. So at this point, going into 2025, we'll be at 5 years, and that audit has to happen. We'll put that on the agenda, status on that audit, and on the joint physical custody issue, I want to revisit the balancing of the joint physical custody and other solutions there for issues when there is one unemployed spouse or ex-spouse. You're not spouses anymore. It's been a little bit, Kim. You haven't been in front of the judges in a while. Get the right language for joint physical custody calculations. And then Judge Rob, you had mentioned perhaps we look at the possibility of collecting evidence on whether balancing the child support would have that actual economic effect on them. Other proposed agenda items. I am going to bring back the one from Legal Services on the issue of childcare, so that will be an agenda item. Ms. Baker, you were about to push your button.
Kathleen Baker. We've had an interesting issue come up a number of times. So we clearly have our guidelines for when we know what a party's income is. And we have guidelines which allow us to find that somebody is unemployed or underemployed and for the purpose of imputing income. What we don't have is when we have one party come in, the payee come in, and the payor doesn't show up at a hearing, and the payee says, well, I know they're working, and I know that they are a construction worker, but I don't know where they're working, and we can't get the other party in, and we can't say they're underemployed, and we can't say they're unemployed because we have testimony that they are employed. And it's what do we do with the child support at that point in time? Do we say a construction worker pursuant to salary levels can earn this amount and then use that? So that's the idea. I don't know if anybody has any other thoughts on it, but it is sort of a gap in terms of what do we do. And we run into that, unfortunately, quite a bit in the enforcement program.
Okay, thank you. We'll add that to the agenda.
And this is April Green, back to that joint custody calculation issue and, getting information and, evidence and trying to come back to it. I just want to say that I think there's a big difference and there's a kind of disconnect with low income, working poor people and people at higher levels of income even when there's a big disparity, low income, high income, those cases are different from the majority of cases. And this is from a legal aid perspective and a self-help center perspective, where the difference in income is often hundreds, maybe a couple of $1,000s, where the child support, say for one child, we're talking about $200 and $300. But so to divide that in half is a great hardship to somebody who's trying to use that $200 or $300 to get the rent paid. So I just think we have to be cognizant that the majority of the litigants are on that bottom strata.
Okay,
And we
well,
gotta
to be careful because we are on just proposing of agenda items. If you want me to reopen that agenda item, we can do it. I just don't want the DAG getting mad at me. Do you want me to reopen it so we can go back? I'm happy to.
Oh, okay. Well, it was just a comment before the last comment that you were talking about it. So, and I did press my button, but somebody else spoke. So,
Okay, well, let's do
I'm
this. Yeah, let's do this because we are on proposed agenda items. And so I was putting it back on for asking for evidence for the balanced child support issue in the joint custody. But let's for a moment go back and say that we are reopening agenda item number 5. I did not want to cut you off. I just know I get in trouble when we start testifying like that, when we're not on the right agenda item. So agenda item number 5, where we were talking about the joint physical custody child support issue. Please go ahead. I'd like you to be able to finish.
okay. No, I'm just saying that when we get to the point of looking at that again, you know, one of the things I will be bringing in information on is what happens when the both people's income is relatively low, but somebody really needs whatever they had coming under the calculation. To me, is different than the person who wrote the letter, you know, and people at higher incomes, high and low, and those kind of things. I just want us to be cognizant of those problems too.
Okay, do we have additional committee comments on that now that we have this agenda item open again?
Judge Hoskin, I do find that interesting. And as she was talking, I'm trying to formulate a way that maybe in those low income situations, we can create a percentage that will get us to the 50% we had in the last one, depending on what the income differences are. I'm just thinking out loud. But I don't want to forget my thought, so I'd like it in the minutes that perhaps a better proposal that would work with all sides is a sliding scale depending on the amount of child support being ordered, where those percentages start at 100% and go to 50%, may solve the issues that we're running into and still achieve what I tried to achieve last time. I hate making mistakes because it'll having to propose language, and I don't that I will have time to do that, but maybe I will. So that I just wanted to make that comment based upon what Ms. Green said, because I do agree with her that the situation is different when the child support is a few $100s than when the child support is a few $1,000s.
I would add to that, though, that at that low of income of the payor, that extra 150 to the other side meant the other side got 300 and that person got that much less. And that extra 150 in their pocket could make a difference of them making a car payment or not making a car payment also. And so I still really worry that the thought that that person is just slightly higher in income means that that 150 didn't make a difference to them and only really matter to the recipient and not the payor. Knowing that knowing that payor also has the children in their home 50% of the time. That's the part that is really hard to understand. And at that income level, paying an extra 150 that you didn't have to pay could make that big of a difference to that side too, and that child having a ride to school or not, or that child having a little extra in that home also. So, Ms. Baker, you were pushing your mic.
Yeah, Kathleen Baker. I think one of the dilemmas that we have when we're talking about low-income families is that neither party necessarily has enough money to make ends meet. And we're always very cognizant, I think, of making certain that custody issues don't revolve around money, and we want children to have access to both of their parents. And I think striking the balance about how each parent is able to meet the children's needs so they can maintain that joint physical custody situation is part of the problem here, especially with low-income people. So I'm just putting that out there for some thought, because yes, the $150 may make the car payment for the payor, but it also may mean that the payee doesn't have enough money to feed the kids. And it's like, how do you balance those things out? They're really problematic for people who just don't have enough money. So just to put it out there, think about when we're putting it in the mix for the next meeting.
I'm not opposed to your sliding scale concept. Bravo that you want to put some effort into it, Judge, to try to come up with a concept. I think also maybe it's worth the effort to, again, look at what some of the other states are doing on joint physical custody and see if there's something we're just not creatively hearing or knowing or seeing. We always, during the first rendition, we saw some pretty complicated stuff out of a few states, like Wisconsin was pretty darn complicated. And part of this was also the goal of this committee was to still had statutes that when the general public read them, they understood what they meant. I can't say we completely achieved that goal, guys, but we tried at times, and there are some of our regs that I have to say are still complicated, but I don't mind also taking a look around and just seeing what else I see out there. Just see if since I'm the one that so passionately has said I have an issue with just discarding the fact that the payor is just well off and doing just fine. So I should look at some resources for some solutions. Judge Rob, you have your hand up.
We've already got a bifurcated system, right? We have the system for low-income people and then the system for workers who are above that level. I think it would be a good idea, and this kind of dovetails with what Judge Hoskin is proposing. Let's concentrate our research on the low income issue. I like our solution for higher income workers. It's the low income where it's the problem, and quite frankly, it's the low income and people being forced to go on public assistance that was what was brought up by DWSS. So if we concentrate there and bifurcate the way we're approaching this, I don't think that does violence to anything that we've done so far.
Okay, thank you. Any additional comments?
Yes, along those lines, I don't know if you all got to see the Nevada's report card on children and how we were like 50, close to 50, almost every marker on children, health, education, poverty, and so on and so forth. And to me, that's related to what we're talking about. So I'll be happy to submit the information I have on that as well. Because at the end of the day, child support is for benefit and the support of children. And I think we have to keep their need up front.
Okay, thank you. All right, I'm going to return us back down to agenda item number 8 for potential future agenda items. I'm going to say that I want to also add a little bit of a discussion of this issue about our authority on, to clarify again what our authority is under the original statutory framework for the creation of our committee, and maybe possibility of discussion of reaching out to the legislature about some of these other issues that are coming forth in front of us. So any other agenda items anybody would like to add?
Madam Chair and Judge Hoskin, I just want to make sure we're leaving on the agenda the updates on what's happening with what we did 2 or 3 years ago.
Yes. So updates on the last recommendations to the division. Okay. Any other agenda items? All right. As I stated, I don't know what to tell you about a meeting date and time at the moment. The two buildings are about to be consumed by the session, and so we're up against the holidays right now. I am going to, the division was not real thrilled with doing off-site committee meetings in the past. I'm going to make a very clear statement right now. We have done them. We did them. We did them a lot during COVID. We did them at the division's office and by Zoom. And I don't necessarily have a lot of patience for that concept. So I do expect and desire that we have meetings during sessions so that perhaps when session ends, any new recommendations we make can move forward. I also make that statement so that the public knows, please continue to reach out. Please continue to give us your thoughts and items for the agenda. Some of these committee members do not practice family law and are not seeing the day-to-day, and some of us are and some of us aren't. So we need you, and we need everybody to give us items for the agenda so we know what's going well and what's not going well, and not just through the lenses of people who are doing it every day and think it's just what it is, okay? We will now move on to agenda item number 9, which is general public comments. Once again, has anybody arrived in the Las Vegas building?
No.
Okay, and we have no one present in the Carson City building. Broadcast, do we have anybody on the phone that would like to give public comment?
Thank you, Chair. To provide public comment, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to provide public comment at this time.
Okay, thank you. I appreciate everybody, and we will now adjourn. And happy Thanksgiving, everybody.
Thank you.